Hi there, welcome to Relitigated, the show where five friends who are absolutely not lawyers attempt to retry a real Supreme Court case. I'm your host, Jarrett, and this is episode 15, Berghuis v. Thompkins, which was decided in 2010. A quick note before we get started. As always, we try our best to represent the facts and decisions in the case as accurately as possible, but we're not lawyers, and nothing in this episode should be taken as legal advice. Okay, with that out of the way, let's start the show.
I'm not sure that person thought Chernobyl was real, to be frank. But that's besides the point. Like that, from the video game Stalker, like what are you talking about?
Yeah. Hi there, welcome to the Relitigated podcast. I'm your host, Jarrett. I'm joined by my co-host, Nikki. Hello, Nikki.
Hello.
We also have with us three friends who will be role-playing as our justices for this episode. First, we have Associate Justice Mike.
Guys, he said I'm a friend. I have a friend.
No, I can't believe it either.
Next, we have Associate Justice Graham.
Hi, everybody.
And lastly, we have, against our better judgment, our Chief Justice Adam.
I can't believe we're all back together again under my wise and judicious tutelage.
Huh.
And modest.
Yeah. So humble.
Yep.
There's a reason I was made chief, guys.
The most humble.
I get things done in the
You
judicious
are
sense.
so modest. If there was a modest competition, you would wipe the floor with everyone.
No, I
That's
think
how
everyone's
modest
ass
you
for
are.
sure. 100%. Yeah. Nah, dog. You know me.
If you're new to the show, here's how this works. Nikki and I have selected a real Supreme Court case, and our justices do not know what case we have selected. Nikki will introduce the case to us and walk us through the facts so we can all get familiar with the details. The justices are free to ask factual questions during this time, and we will answer them as best as we can. Next, we'll move into oral arguments where Nikki will role-play as the petitioner and I will role-play as the respondent. We each get 7 minutes to make our case, during which the justices can interrupt us and ask probing questions. When the arguments are over, the justices will deliberate and deliver their own opinions. The final rulings do not need to be unanimous. Majority opinion wins. Even if two or more justices agree in principle, they can disagree as to why specifically. Once we've had our fun with our mock hearing, Nikki and I will reveal what the Supreme Court really decided and talk about how we feel about the actual results and why this case matters. Sound good to everyone?
Sounds great.
Sounds gravy.
Huzzah.
Awesome. I'm going to turn it over to Nikki for the facts of the case.
Okay. So we brought you guys here to talk about police interrogations.
Yay, again.
Round 2.
I love it. My favorite topic.
I was just like waiting all day for this.
And follow up
Send the
to-
Marines in, is what I say.
My favorite thing is building carefully considered police strategy through the judicial bench. Let's do it.
in response, or in follow-up to Butler v. North Carolina, which will be a previous episode in your feed if you'd like to go back and listen.
Or was it North Carolina v. Butler?
It's going to be one of those two.
Yeah. I mean, those are the people involved. So, our case for this episode is Berghuis v. Thompkins. It all begins with the shooting outside a mall in Southfield, Michigan, that killed one man and wounded another. The suspect in the crime, VT, fled the state, but was found a year later in Ohio. So, two Southfield officers traveled to Ohio to question VT about the crime before their transfer back to Michigan. The interrogation took place in an 8 by 10 foot room with VT seated in a kind of schoolroom style chair desk combo. At the start, the officers provided VT with a form concerning their Miranda rights that read as follows. So this is a notification of constitutional rights and statements. 1, you have the right to remain silent. 2, anything you say can and will be used against you in a court of law. 3, you have a right to talk to a lawyer before answering any questions, and you have the right to have a lawyer present with you while you are answering any questions. 4, if you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning, if you wish one. 5, You have the right to decide at any time before or during questioning to use your right to remain silent and your right to talk to a lawyer while you are being questioned. To confirm that VT could read and understand English, the officers asked them to read this fifth statement out loud, which VT did. Then, the officers read out the first 4 statements to VT and asked them to sign the form to acknowledge that they understood their rights. But VT declined to sign the form. It's possible that VT verbally acknowledged that they understood their rights, but the record is conflicted on this point. Following the Miranda warning, the officers began their 3-hour interrogation, and for about 2 hours and 45 minutes, VT remained mostly silent. There were a few small verbal responses, mostly things like yeah, no, or I don't know, as well as some head nods. VT also stated he didn't want a peppermint when asked, and that his chair was hard. Apart from these few interactions, as noted in a Wall Street Journal article, the police themselves considered it, quote, nearly a monologue, unquote. During this period of near silence, VT never said that they wished to invoke their right to remain silent or their right to an attorney. Instead, they were just mostly silent. At the end of the interview, the officers changed tactics and asked VT if they believed in God. According to officer testimony, VT's eyes, quote, welled with tears, and they replied yes. The officer then asked, "Do you pray to God?" And again, VT replied yes. Finally, the officer asked, "Do you pray to God to forgive you for shooting that boy down?" And VT also replied yes. VT was ultimately charged with first-degree murder along with firearms-related crimes. At trial, their defense moved to suppress the statements that VT made during the interrogation, arguing that VT's silence during almost the entire interview was a clear invocation of his Fifth Amendment right to remain silent. The motion was denied. Ultimately, VT was convicted by a jury on all counts, and they were sentenced to life without parole. Something else to note about the trial before we move on, there were a couple of other things that happened concerning the testimony of another person who was allegedly in the vehicle with VT at the time of the shooting and ineffective counsel. But to keep things simple, we're going to disregard all of that for this episode, and we're just going to focus on the interrogation and its results. So, following the trial, VT appealed their conviction to the Michigan Court of Appeals, arguing that the trial court should not have allowed VT's statements at the end of the interrogation to be used against them, since they'd been clearly invoking their right to silence. The appeal was rejected by the Michigan Court of Appeals on the grounds that VT had not invoked their right to remain silent. Next, they filed a petition for a writ of habeas corpus with the U.S. District Court for the Eastern District of Michigan, but the petition was rejected as the district court also found that VT had not invoked their right to silence. Undeterred, VT appealed to the U.S. Court of Appeals for the Sixth Circuit, arguing once more that they had not waived their right to silence. This time, the court agreed and reversed the decisions of the previous courts. They wrote in their decision that VT's, quote, persistent silence for nearly 3 hours in response to questioning and repeated invitations to tell his side of the story offered a clear and unequivocal message to the officers. VT did not wish to waive their rights, end quote. In response to the reversal in the U.S. Court of Appeals, the state of Michigan appealed the ruling to the Supreme Court, meaning it is up to our justices to decide. Do you have to state explicitly that you are invoking your right to silence, or is remaining silent enough? Now, if you're thinking that this case sounds a little familiar, it's very similar, but not exactly the same as North Carolina v. Butler, which the three of you heard in a prior episode. So as a quick reminder, in that prior case, WB refused to sign a form acknowledging their Miranda rights, never asked for a lawyer, participated in the interrogation, and then appealed their conviction on the grounds that their statements to police should have been suppressed since they never declined a lawyer and a lawyer wasn't present. The Supreme Court disagreed, arguing that talking to the police implied that he was waiving his right to counsel. All right. Be good? Everybody got it? Any questions?
We are quickly becoming experts on how and to what limit the police can interrogate people. Very exciting. Establishing a niche in the law. Also, this feels a little bit clear cut to me, and I hope to eat those words as the complexity of this case unfolds before us. But like right now, like it's like that riddle where you have two guardians in front of the door, and they're all like, one of them always lies and one of them always tells the truth. How do you? It's a paradox. How do you invoke your right to be silent unless you don't be silent? I digress. I rest my case.
Any factual questions for us before we get into arguments?
No. Just rhetorical navel gazing. Factual questions. Yeah. So one factual question would be when it says almost a monologue, like, so is it just the peppermint and the chair thing? Was that the only things that he said other than those final three leading questions?
As far as we can tell, yeah.
Okay.
Yeah, it's so in the documentation, we don't have the transcript of the interrogation. In the documentation from the Supreme Court and what we could find, they did note, or at least the officers noted, that there were a couple of times where there were like head nods, or they would say the individual said yeah or no, like one word sort of perfunctory responses, but we do not know to what questions or even if they were questions that they were responding to.
And the primary thing that he was convicted on were those last three leading questions.
Yeah, what was the conviction based on?
So there was other, and I think that's what some of the other arguments hinged on, but the statements made to the police was definitely included in the evidence against him.
Yeah, but like, I'm curious as to what.
He was also soaked head to toe in blood.
Yeah, I mean, like, was there other damning evidence? Like how much did just this last question seems like is that the evidence of, hey, we got an admission?
Basically
or
my question,
like,
yeah.
Do we have bullet matches up and we found the gun that was used at this, like,
I'm going to look it up real quick, but I'm also going to comment that one thing that law people complain about is that juries expect too much in terms of evidence.
Wait, that's a complaint?
That's the most terrifying thing I've heard in a minute.
That sounds like the law person's problem, not the jury's problem.
Like a lot of, just based on, watching the CSI shows, everybody's always expecting like DNA and stuff. Throwing that in there.
Well, I'm not looking for DNA here, but do we have like witnesses recognized him? We found a weapon that matches the weapon used in the, like,
So while Nikki's looking that up, my response to that question is, it won't be relevant to the legal question at hand.
Shut up and focus, dummy.
But basically, they do have testimony from basically a co-defendant. And I'm looking through things and I'm trying to sort out the prosecution theory versus what was actually,
So maybe we can
theorize
that the nod that he praised for the victim is like the cherry on top for the jury. Like, oh man, that makes him look real guilty, in addition to the pocket full of spent shell casings.
Yeah,
or whatever it was.
I guess it doesn't affect the actual question we're going to answer, but still some context to the case, I think, would be helpful.
Yeah, if I remember correctly, this was a drive-by style shooting. I think they were actually maybe stopped at like a stoplight or something like that. But there were three people, allegedly there were three people in the vehicle, and this individual was the one who fired the shot that wounded one person and killed another. The person who is driving was acquitted, if I remember correctly, and when they testified at trial, they never identified this suspect as they said, I was looking at the floor trying to fix
I was bending over on the floor.
So I'm not aware who fired the shots.
You don't snitch.
But then did see after the shooting, VT holding a pistol.
Oh, well, okay. Kind of snitched.
That apparently, if you want to go back afterwards and actually read up on the case, apparently that was a bit of a bone of contention
Oh, yeah.
Potentially between that individual and our
there was a lot of
family
back and forth with the. There was a lot of kind of stuff going on also with the co-defendant, and because each person had their own kind of agenda.
Oh, did they do the prisoner's dilemma thing?
No, not for interrogation.
They did not flee together.
I was promised there wouldn't be any game theory in this episode.
That is a thing that we put on the release form, for you. So that is fair. Yes.
Yeah. No cognito hazards. Thank you.
So Rocco's basilisk. Let's talk.
Yeah. So not germane to the legal question, but hopefully that provides you some context.
All right. Fair enough.
Yeah, I'm just trying to get in the head of when they go to appeal it. Was it like an absolute Hail Mary appeal, or was it like, dang, the whole court case rested on this? Of course I'm going to appeal it.
There were a lot of different arguments that were made for some varying in how obscure they were. So there were multiple, which is actually pretty common. Hey, I want to appeal my case because of this, and this problem. And so the court has to kind of work through all of them.
Mm-hmm.
Any other factual questions before we move on?
I don't think so.
Cool.
Do we know why he was only asked to read the fifth statement?
You got time to sit there and listen to someone read 5 different statements? Come on.
My guess is the idea is they just pick a number and they ask the person to read that one in order to determine if they understand English and could respond
and are
enough
actually
to be able to respond to instructions,
and actually are reading versus parroting.
Right.
Got it.
Yeah.
So he actually read it.
Yes.
Cool.
And then that's what they use to say, we believe that this person speaks English, understands English, and can read English.
And there wasn't, I think, maybe it was the last case or one of the other cases, there was an issue about maybe being drunk or some. No, that wasn't one of our cases, but no issues of that in this case.
No issues of any alcohol or substance intoxication.
Yep.
No issues raised with reading levels.
So to summarize, guy signified that he understood his rights, yet did not sign the waiver to remain silent, but then just stayed silent.
I think
basically that's the general gist of it. Yeah,
it's I do not waive my right to remain silent.
It wasn't a.
I guess that means you don't have to talk.
It wasn't a waiver. It was just a form, basically acknowledging that they'd been informed and understood.
Wait, so that's rights. What he wouldn't sign. This the form that says I.
Correct. Yeah,
I
have received the instructions of my rights. I'm acknowledging that you did your job. Yeah, not a waiver of rights, a acknowledgement of having been read rights.
Another question. Is it common police practice to conduct an interview for 2 hours and 45 minutes where the person you are interviewing says essentially nothing?
It's a slow day, Graham.
Were they bored?
So, I think I have a little something in here. I don't know if there's any, stats in terms of and people not saying anything, but most interrogations last 30 minutes to 2 hours with a mean length of 1.6 hours. And this is from a review by Casson and colleagues.
Holy shit.
I guess it depends on how effective your torture method is.
Yeah, the bad cops can get real bad.
Are they speed running it?
Yeah, or you can speed run it.
You go right to pulling off fingernails with pliers. You probably get that interview done pretty quick.
Any more factual questions?
Nope. I think we're good.
Awesome. Okay. So Nikki is the petitioner in this case, which means Nikki will be representing the Berghuis, who was a warden, I believe, at the prison where VT was being held.
It's a warden.
Which basically means Nikki's representing the state of Michigan.
Yeah. If you run a prison or if you're in charge of a prison, you're just getting named as a defendant in lawsuits.
Yeah, I was actually going to ask, well, why is his name on it? What did he do?
Because he was the guy whose name was on top of the letterhead. So
it's surprised it's not Michigan versus Thompkins.
It might have been a woman.
Mary Berghuis.
If we can gender this person just based off name alone. Look at us, assuming male-only wardens. Okay, I have put 7 minutes on the clock for Nikki. Her time will begin as soon as she does.
Okay. Sir Justice, and if it please the court, here we are again, hashing out yet another unnecessary Miranda issue. We've already talked about this. We've been over this in Butler, and yet here we are again in search of a magical incantation. Here we are again searching for the forest amongst all these trees. The Fifth Amendment grants us protection from compelled self-incrimination. There was no compulsion here, and therefore no violation of the Fifth Amendment. As the court has held, it's about whether the defendant knowingly and voluntarily waived his rights, and VT did that here. This court previously held in Butler that silence, an understanding of one's rights, and a course of conduct that indicates a waiver is in fact a waiver of rights. We don't need a stack of paperwork or a magical phrase, and the court has previously recognized the implicit waiver. VT read the form out loud. The form clearly laid out his rights. He did not say that he was unwilling to waive his rights. He did participate in the interview. He just participated selectively. He chose to answer some questions, just as he chose not to answer others. When he chose to answer a question, he then waived his right to silence. This is the essence of knowing and voluntary participation. There's nothing that occurred before, during, or after this interview to suggest that he was impaired in his understanding or his ability to understand the rights that he was informed of. There is no reason in the record to date to think that he did not know that he didn't have to answer questions. As stated in Butler, a waiver of rights can be inferred from the individual's awareness of or having been informed of their rights and then engaging in behaviors that indicate that they are choosing not to exercise those rights and behaviors that specifically communicate that they are not exercising their rights. Once again, we don't need a precise phrasing. We can draw the inference from the individual's words and actions. The point of Miranda was to make sure that a suspect was informed of their rights when interrogated. The courts just need to consider the facts and circumstances of the case and consider the context. In this case, VT was informed of his rights and behaved entirely voluntary. The police didn't threaten him. They didn't harm him. They didn't make any improper promises to him. So the police satisfied the requirements of Miranda, and as such, they have discharged their duty. I think with that, I will take some questions.
I don't have any.
So what? I'm just gonna be pro cop again. That's
yeah, it's a compelling argument so far.
Okay.
I want to see what Jared cooks up.
Yes. Justice Graham, I would say so. It's pretty cut and dry.
Well, you would say that, which is why we.
Yeah, I mean, of course you would. This whole so I may have acknowledged verbally his rights. Record is conflicted.
Mm-hmm.
Did he mumble something?
So there's a lot of back and forth about he said, yeah, I received them, or yeah, I understand, versus, claiming he didn't. But in any case, there's nothing to suggest any inability to understand.
Did he say why he refused to sign the form?
So I think a reasonable interpretation could just be caginess, not wanting to sign anything, wanting to listen to what police had to say, maybe answer something but not answer others?
So I'm not sure that this question is directly for you, but maybe just it's a global question. But like, is silence interpreted in the U.S. court system as like literally like sounds coming out of your mouth flapping, or does silence also connote like written words on a note, or sign language?
I think if this individual were deaf and communicating in sign language, that would be considered speech. That wouldn't be remaining silent. So I don't think it's a strict literal interpretation.
What if they like wrote "I did it" 100 times on a note while no one else is in the room, and then they crumpled it up and put it in their pocket? Is that silence or not silence? I should say. Is that breaking their silence?
if it's within view of other people or within view of cameras,
then it's expression and therefore
or somehow retrievable. Yes.
Okay, interesting. What about interpretive dance? All right, never mind. So I'm just trying to say, like silence, I guess, shouldn't be considered just in the context of somebody speaking, right? It's broader than that, and therefore his nods are effectively communication.
It's conveying information in response to questions put to him.
I'm gonna have to side with the cops again. All right, no further questions.
Yeah, this might be a tough one, Jarrett. Wow, I'm looking forward to it, actually.
Yeah, no pressure.
Maybe I'll yield the last 45 seconds, or I'll save that for...
You should sing a song.
I'll what is it? What's the rule? How's that work? I'll save it for later.
Think of the song quickly. There's only a few seconds left now.
Yeah, that would actually help your case immensely, counselor.
I will reserve 45 seconds for you if you like.
For a song.
Yeah, sure.
To be used only for a song.
Only for a song. Oh man, I love going second and hearing, I agree, Nikki.
Unfamiliar spot for you, for sure.
Yeah, no, I've never experienced such a...
This is your show. You don't have to do this to yourself.
They make me.
It's the shadowy cabal of producers who bankroll us.
Yes. That said, looking for sponsors.
Non-shadowy cabal. Step right up.
Bombas Socks, where you at?
Relitigated.com. Look us up.
I would love to read your 3.5-minute sponsorship message.
All right, I am ready whenever you are, Nikki.
Okay.
Since it doesn't matter, apparently.
Hey man, listen, just because I was excellent, no reason to be bitter. It's fine. But yeah, ready when you are.
Okay. Mr. Chief Justice, and may it please the court, very basically, if the police inform you that you have the right to remain silent, doesn't it make sense that in order to assert that right, you remain freaking silent? At the heart of this case is a contradiction of procedure that I believe this court can fix. In Miranda v. Arizona, the court asserted that the police must advise you of your rights and that you must waive your rights in order for your statements to be admitted into evidence. So if my right is to remain silent, and you just told me that it's my right to remain silent, why do we expect people to say anything in order to be silent? In Butler v. North Carolina, the court said that you only get a lawyer if you specifically request one. That makes some sense. You can't leave and get a lawyer while you're detained, so you have to ask for one. But this case is not the same, no matter how much the petitioner wants it to be, because I don't have to ask for anything to be quiet. I can just be quiet. How long does someone have to give you the silent treatment before you realize that they're giving you the silent treatment? If someone doesn't respond to 3, maybe 4 direct questions, wouldn't we all assume that they're giving us the silent treatment? 2 hours and 45 minutes of talking at someone wasn't enough to make the police think, hey, you know what? Maybe this silent person heard us say you have the right to remain silent and is doing just that. After 15 minutes, this interrogation should have ended with the obvious conclusion that the police informed the respondent of their right to remain silent, and the respondent then remained silent, thus asserting their right to silence. The state will say that the respondent did respond to questions about wanting a mint or how comfortable their chair was, so they were cooperative and answered the police questions. Is the state serious? Those were not questions about an alleged crime, those were pleasantries. Let's take their logic one step further. Did the respondent answer any questions about the crime after refusing the mint, since that was such a huge sign of cooperation? No, they remained silent. So, maybe we're talking about different kinds of questions here. The respondent was smart enough to recognize this. Why can't the state? Why is the standard that the citizen, alone in an unfamiliar room, under bright lights and in an uncomfortable chair, is expected to boldly and without error assert with perfect clarity their rights? With all the power and resources of the state, shouldn't the default be that the citizen waives their rights when they make it clear that they wish to waive their rights? This is a system that is set up to prey upon the poor and the poorly educated, citizens who do not have the knowledge or the means to fight their detention must square off against trained interrogators with all the power and resources of the state. They're expected to be experts, and the experienced police officers only ever have to use basic common sense when it's in their favor to do so. This doesn't make any sense. This should be reversed. This is a classist system, and given our history as a nation, that often means it is also a racist system as well. Finally, consider this. For 2 hours and 45 minutes, the police questioned a witness who was silent and would not even look at them, except to refuse a mint and remark that their chair was uncomfortable. Almost 3 hours of this, when it's so obvious they don't want to talk, is coercive. The police obtained their flimsy admission by placing someone under strain and hitting him with wave after wave of question for nearly 3 hours, pulling teeth. Put yourself in their place. At what point would you crack? At what point would you say something sarcastic? Because, let's face it, that's everyone on this call would probably do that. It's not like you know that there's a time limit. You just want to get out of the room. Justices, that is coercive at minimum, and it is torture at worst. What part of this feels willing and voluntary to you? So, if the Fifth Amendment means anything, and if the Miranda v. Arizona decision means anything, you must strike the respondent's statement under duress from evidence. Thank you, and I yield to questions.
Every now and again, I just think that I might just be gullible because I'm back in. Anti-cop. I'm in. Let's go.
I actually do have a question. Going back through the facts of the case notes, you mentioned the chair and you mentioned the peppermint, but it clearly states here he occasionally responds with two things with a yeah, no, or I don't know, or a nod. What questions were those in response to?
Conveniently, the state did not tell us to which questions those were in response to. Perhaps they asked him if he would like a coffee.
Do we have a recording?
Not on the record.
We probably don't, but is there a recording?
Not on the record.
Not on the record.
Is there some sort of requirement for, okay, so if I allegedly am at my job, allegedly at working from home, and I'm away from my computer for a long time, allegedly, my Microsoft Teams goes from green to yellow, allegedly, and I have to wiggle my mouse to where it goes back to green. Is that the same kind of principle that the police are using when they're asking him, to your point, counselor, these pleasantries? Is there some sort of time limit that they have to ask that they have to receive a response before they can terminate the interview, or they are forced to terminate the interview?
Do they wiggle this man?
It's the police's contention is probably no. We will keep you here as long as we want to and ask you until you finally start talking to us. Which I believe is a coercive move on behalf of the state and should not be allowed. I'm asking for the court to perhaps put in place some boundaries upon the state to say, hey, use common sense. This person who you told, you have a right to remain silent is doing that. And, the state needs to have some onus here. Right now, the onus is entirely on the citizen. If you don't perfectly say the magic words, then you don't get a thing as a citizen. That is ridiculous. The state should have the burden, not the citizen.
So when somebody in real life, like following a courtroom drama on TV, says, "I want my lawyer shows up," do the police have any latitude to like question the lawyer or like filter questions to the defendant or suspect, I should say, via the lawyer? Like what happens then?
All of the questions
they process
are
them
asked.
to jail and
all the questions are, in that case, all the questions are asked to the suspect in front of their lawyer, and their lawyer has the opportunity to
decline to answer,
to confer with their client.
Okay.
So essentially, the interrogation continues, but you have an advisor on your side.
So theoretically, the entire proceedings in this case, the 2 hours and 45 minutes, those could have happened exactly the same way. If he had said up front, "I want my lawyer," lawyer had showed up, they could have proceeded with that 2 hour and 45 minute rigmarole just the same.
Except it's possible the lawyer
would have,
if a lawyer had been there, would have said, "Guys, it's been 15 minutes," and he said nothing.
Yeah.
Or actually, probably the lawyer would have said, "We're asserting right to silence."
I know we're at time, but I want to pursue this for a second. What if lawyer says it's been 15 minutes, this guy's not saying anything? Cops say, "Don't care. You want gum? No. You want some mints? No. You want some runts?"
I think the way it works is the lawyer says, "Assertion to right of silence. Get up and walk out."
Okay.
Or you can continue to detain him, but we are done answering questions.
It's like, the police just offered you nerds. I advise you take them. They're very good. All right. That answers my question.
I am out of time, but Nikki has 45 seconds.
Did you come up with a song?
No, I am not a songwriter at all. I just have a few thoughts that I'd like to share. One being that Jarrett really hasn't explained, given that the person is the expert in their own experience, how offering a mint and inquiring after one's comfort is inherently coercive. And, as Justice Adam was kind of asking about in his questions, silence is not an absence of communication. And so what to make of a nod or a head shake or a dance, especially even after being informed that anything they say can and will be used against them. And VT understood that. There's no question in the record of any of his understanding of this. And I'm at time.
I didn't realize you could do that. I didn't realize you could reserve time and save it up for a retort. That's awesome.
Oh, Jarrett's done that.
This is like high level Street Fighter. This is great.
Well, that's what court is. Or how back in the day we had trial by combat, and then we're like, that's too bloody. Like, lawyers are basically the modern day.
Gentlemen, like, we should punch each other with words.
I'm going to need Joel to not give the current powers that be any suggestions.
I mean, I'm just saying in theory.
Point and counterpoint. I think we have this notion of like, prosecution gets to question a witness and then they are done with that witness and then defense gets to, but it actually can go back and forth.
It goes back and forth.
They just keep redirecting.
There can be redirect to clean up anything that came out on cross, and then there can be recross in order to get on anything that came out and there can be re like until everybody's like tired.
Yeah, it's not just one and done. So I see that very rarely, but occasionally on courtroom dramas.
Well, they've only got 30 minutes.
Well, everyone is done.
But courtroom dramas are our number one means of educating the public on how the court system works.
Unfortunately.
I say, actually 100% seriously.
If that's realistic, then enhance. Enhance.
I think since we're all out of time, I think we have to move into deliberations. Unfortunately, I would love to answer more questions, but I do not have the time for that. So
I do actually have a
I'm
question.
definitely not giving Nikki any more time.
This
Aw,
doesn't
come on.
mean like not necessarily asking you as your lawyer self over there. You guys are real lawyers, right?
100%.
Okay, just making sure.
Oh, yeah.
Damn it! We have been over this.
We are. Yeah, I went to the school of my imagination. Got my legal training there. It was great.
Yeah,
No debt.
Wikipedia you.
Did VT eventually get a lawyer, and when did the lawyer enter the case?
That I don't think we could
After
really tell.
Post-interrogation.
I guess
When it was too late.
So, like,
did he
yeah,
get a
somebody
lawyer? Was it like a state appointed after they were done, or?
I mean, usually if a person doesn't like invoke, then it's like when they're held and then they go to court to be arraigned and like formally notified of their charges. That's when they get the lawyer. But we don't know based on this record, what happened in this case.
Okay.
Nikki and I have returned to being clerks. We have reached the deliberation phase. Good luck, justices.
This one's tricky. Because on the one hand, like, pretty clear, like what Jarrett was saying, like, you don't, how else do you invoke your right to remain silent other than just shutting up? Like, it's counterintuitive. You have to break your silence to invoke it specifically, whether, you're breaking that silence verbally or doing it in writing or interpretive dance or mime or, whatever. So that makes sense. But on the other hand, he did kind of incriminate himself. He did nod when asked a very incriminating question. And that, in my opinion, is breaking silence through a gesture. However, that happened after an inordinate amount of time in captivity when it was obvious, to Jarrett's point, that this man did not want to be answering any questions. So this case is not about this case, man. It's about how long the cops can hold you reasonably when questions are not being answered, I feel like. And given that that's kind of what it distills down to for me, I feel like the cops held him too long.
I actually think I agree. I think that if we are operating under the confines of kind of the law as we know it, the status quo as we know it, I think that I find it hard not to agree with Nikki. However, I think the bigger picture, the bigger point is it's kind of crazy that they held this man for 2 hours and 45 minutes and he was saying nothing or essentially nothing.
That is a little psychopathic.
It's nuts. So I think that I'm in favor of ruling to change some of the rules, if you will, change some of the laws around. Can we do that? Can we change rules? We're the Supreme Court. We can do what we want.
We can do anything. We're all too powerful.
Who's going to stop you?
The cops have to answer a question for every question that they ask to keep it fair. No? Okay. We'll try again. We'll workshop that one.
If he doesn't answer by the time his team's notification allegedly changes to yellow.
Yeah.
You cannot waggle the suspect under any circumstances.
I know that I and everyone else will regret the following, but you can, if you choose, create some sort of rule or test.
They have to define what an R-square is and interpret a linear regression.
This is just reminding me of the shenanigans doctrine or whatever it was. Shenanigans test.
I guess the question would be, if you're going to if you don't have to unambiguously invoke your right to silence, which is the question, then can it be implied? If we're going to go with law stuff here, we need to have some hard and fast rule for what is implied, right?
Law axiom, silence is silence. I'm going to go ahead and make that bold proclamation.
I would love to know the context in which they, like, I know they said the last 15 minutes is when they started getting the yeses out of him. Do you believe in God? Yes, with tears in his eyes. First of all, very specific detail that the cops threw
like
in
while
there.
he's still nodding, agreeing to that question, like, did you kill that man? Do you feel bad about it? He's like still nodding along.
Yeah, I'd love to, get a feel for the timing of all of that. But
Murderer says what? That is not admissible in court, sir. Yeah, it's and furthermore, like,
innocent man wants a peppermint.
Only guilty men like breath mints. So, yeah, that last 15 minutes thing is kind of interesting because, like, it's based on the sporadic, like, non-answers throughout the thing. Like, all of a sudden, he's like nodding along to some questioning. It's kind of interesting. He must have hit some physical threshold at some point. Maybe he needed to pee really badly. He did say the chair was very uncomfortable. Maybe it had sapped all of his hit points and he was about to die. So I am curious about what the state of mind was in those last few minutes. I don't know. I am having a lot of trouble sympathizing with the state on this one.
I mean, I'm on board with the maybe you don't have to well, I guess actually the question is a little different. The question is, do you have to unambiguously invoke your right? But yep. Jarrett's argument was he did unambiguously invoke his right.
By being silent, yeah. But then that does raise a difficult anti-test for the police of, like, how long do they have to remain silent? Is it like 20 minutes? And then they're like, okay, it seems like you're not. You're not
like how many tests? Okay,
does it
he
reset
the paper? What else? Like,
yeah, and I think that there's potential then for people to game the system. I mean, I joke about the wiggling your mouse, but I do feel like we
allegedly wiggle your mouse.
Allegedly. I said allegedly. You can't prove I didn't.
Mm-hmm.
You do want to make sure that we have a test that doesn't just open itself up to the police now being able to game the system to where they have these interviews extending for longer and longer and longer and longer just because somebody is satisfying some sort of test.
I mean, it's like, if not saying anything implies that you are invoking your right to silence, what's the limit on that? Like,
sorry, say that again, Mike.
Well, okay, we're saying, if the person doesn't talk, then we're saying, no, that they've implied that they are invoking their right to silence.
Mm-hmm.
Like, how many questions do you ask before it's like, because we're going to put this into like a law thing, we need to have some like actual standard quantitatively here, right?
That's what I was saying. Like, is it 20 minutes of non-answering, and that would point you like, okay, this man is silent. He has invoked it. He's invoked silence.
Do you ask? Do you invoke your right to silence, and then what if he
throw away the key?
What if he doesn't answer that?
Yep. Oh no. Okay. Universal gesture. You got to go and then throw away a key, and that is the nonverbal affirmation that you have invoked your right to silence.
I mean, should the state just straight up ask at do you invoke your right to silence? Was that ever asked?
Are we about to reinvent Miranda? Is that
wait, is the state even allowed to ask that though?
Wasn't that the point of the form that he was supposed to sign?
Yeah.
We've come full circle.
The form was just acknowledgement of, that the rights had been explained.
But wait, I feel like this form needs to be amended.
The form is like when you go to the doctor's office and they give you like the HIPAA policy, and then they have you sign a form that says they gave you the HIPAA policy.
Yeah, but in this case, it would be like a form like you got it, and do you agree with the HIPAA policy? Which is not, the analogy breaks down, but like I feel like
you understand your rights, and like, do you wish to invoke any of these rights?
We just need another checkbox on the form, and we're golden. I feel like there's our test.
Is that ADA compliant?
That's how bureaucracies grow.
This is a UX problem. So instead of a fun, pithy, branded new judicial ruling or test for the future, we're just going to
more paperwork.
Make a mundane operational paperwork modification.
Just update the PDF.
Yeah. Yep. We'll get the interns on it. It's actually a ChatGPT problem. We'll take care of it. Yeah, I think we did a justice, guys. We fixed the clerical process and made a great justice in the process. No, wait, we're off track. Hold on. There are bigger questions at hand here. The biggest question I really think at hand here is like, how long can they reasonably hang you out in that awful room before they have to let you either go or arrest you? Doesn't that feel like the question, real? Like, lawyer or not, you're if you are not responding, or you have invoked your lawyer and the lawyer has advised you to not respond to these questions, in either case, I think the outcome's the same. How long can that go on? Should that go on before they're just like, okay, you're free to go, or we have to arrest you? That feels like something that could have a definitive standard put in place.
Well,
does that exist?
He's arrested either way. I guess it's how long does the questioning go on for?
That does kind of get us back, though, because what defines him not answering? You know, our definition of not answering could be 2 hours and 45 minutes of near silence or almost silence, as the police describe it. But, you know, you would feel like it would need to be complete silence. You know, if he's responding to anything, then the police...
Timer resets.
Right, the timer
every
resets.
time he nods.
Yeah.
Also, nodding is an ambiguous form of communication. Like, you could be nodding because you're falling asleep.
Yeah. Different cultures have different uses of nods. Yeah.
That's true. That's very true. I forgot what we're supposed to be ruling on right now. What is the core question at play here? We've gone way off track.
Do you have to unambiguously invoke your right to silence, or can it be implied by just being silent? And at which point should police stop the interrogation?
Yeah, I think that it's implied. Silence is silence, and not silence is not silence, and you invoke your right by being silent. And then I think the question is just a matter of how long can they keep you?
Okay, so I think we're all in agreement on the first part of that, right? Like, yes, if you're silent, you're invoking your right to be silent.
I think that, if I may, that it is our responsibility as this high court to make sure that the laws are precise and clearly defined. And so I think that we need to be very specific as to what silent means. Does silent mean no nodding, no nothing, you are sitting completely still?
Yeah.
Or, you know, what is silence? Because I think that if we are not precise, then there will be cases down the line where we will have to relitigate this.
Two things. That is one. Relitigate. I see what you did there.
You see?
I got it.
You see the
Hello.
Two things. Yeah, so that, and then what is the time threshold at which, all right, you've reached the test of being silent you've done what we consider being silent for long enough that you are now considered silent. Congratulations. Here's your hat or whatever.
The crazy thing that as I rethink about the core question is, I think that by asking all of these questions, we are answering kind of the question at the center of this, which is, can it be implied? It's like, yes, but like there is a...
Is this the porn thing where I can't define it, but I know it when I see it?
It really is, because if they're like grinning and nodding to everything the police are saying, and then shaking their head to other things the police are saying, like, that's clearly communication. But if they're just like nervously rocking and the police say that that's nodding, that's a very different thing. So
or if they just say I'm not invoking my right, but then just stare ahead unblinking for 4 hours.
Or make a high-pitched sound in response to everything the police say, which is not technically being silent, but you're not conveying anything meaningful.
Yep. Or just answer every
this
police
is a
question
complicated
with a question.
one. Oh, damn it. Got us again.
Yeah, what if they answer every question with a question?
You made me think again. Yeah, answering. What if they answer in a complex series of riddles that just bewilder and confuse the police and make some of them vaguely upset with longing and ennui they can't explain? That would be upsetting.
I think that we can... I almost feel like I want to take slices of both of this, right? Both sides of this.
Slice it up.
I think that you have to unambiguously invoke your right to silence. However, I think that we can put a standard in place where there isn't the 2 hours and 45 minute quote unquote monologue from the police to the person they are questioning. Like, we can put standards in place to where it's not such a ridiculous amount of time in set of circumstances. But I do think that there has to be a very specific answer. And also, it is preferred if you just unambiguously invoke your right to silence.
Please just tell us you're invoking the damn right to silence. Come on.
Damn it. We're about to do it, aren't we?
We're right back to update the form. That's our dramatic Porque no los dos for this episode is update the PDF. Yep.
Yeah.
Yeah, I think we're in agreement. The man was invoking his right to be silent by being silent. When you put it that way, it seems so obvious.
So it sounds like you're coming down on the. I'm actually not sure. Which side are you coming down? Who are you siding with?
Yeah, what is
any of this?
We have no idea. No. We are bloviating in circles.
We were trying to get away with this, but no, you're requiring us to get more specific.
We need like a one-liner for like the episode
can
like
we
wrap up.
Unambiguously rule on this, or a ruling can it be implied?
So imagine that all these legal scholars are going to be reading what you have to say and like analyzing it deeply and teaching it in law schools. What is it that you?
I think we all came down on the right that if you're being silent, you're being silent. But then we have to have the second part. I don't think we got to answer, which is like, what is the time limit on questioning that makes that go from implied to unambiguous?
I'm gonna go ahead and call this the cold pizza question. It's how cold does a pizza have to get before you don't want to eat it no more?
That's so stupid because I will just eat pizza out of the fridge.
I am always as hungry as there is pizza in front of me.
Maybe this is too subjective.
Out of the freezer? Pizza out of the freezer?
Okay, freezer, I get, but that doesn't just get you actively make that.
All right,
cold.
this metaphor.
I thought you were going to say. I thought you were going to say you get as long to question somebody as it takes for the pizza you ordered to get cold.
Oh, yeah, that's absolutely what I meant and failed to articulate. Yep, 100%.
Pizzas take a while to get. They come right out of the oven, though. That's
last time I had a pizza.
And what counts as cold?
Yes.
We need temperatures here.
Oh my God!
I got some Domino's the other day.
Are we measuring the bottom of the crusts?
Yeah.
The bottom line is, if you're silent, you're silent, and the cops shouldn't be able to hold you for an excessive period of time. What is excessive? That's for another episode, listeners.
So basically, long enough? Like, if you're silent for long enough, the cop should figure it out?
I remember the last thing we said. It was like the pornography thing of like, I can't define it, but I know it when I see it. I feel like we can try to define it here. At least we can put some bounds on it if we can't define it exactly.
But it's a difficult question because if the suspect is like maniacally smiling and nodding along to some questions and shaking their head to others, that's clearly communication, even if they're being verbally
I would
silent.
say like that's not being silent.
It's verbal silence. But
silence, like non-communicative.
Yes,
let's replace silence with lack of communication.
Yeah. I think that's the biggest problem with the right to remain silent part of the Miranda rights.
Yeah,
it should be any communication whatsoever.
Yeah, you have the right to remain non-communicative.
What is how long or what degree of no communication before it kicks into being unambiguously okay? You have like triggered your right to remain silent. Like the if then statement has gone to true and we are now silent officially.
Yeah, I really like Jarrett's pizza doctrine. And we're gonna go one layer deeper. We're gonna make it the Chicago deep dish pizza doctrine. It's the amount of time that a Chicago deep dish pizza takes to get cold, which by my reckoning is an hour.
We'd have to time that. We have to do some tests.
With a pizza.
And like what part of the pizza are we like talking about? Because like a Chicago deep dish, like the inside, it's going to be warmer for longer.
You stick a probe thermometer in the middle and it comes up the same temperature as if you stick the probe thermometer in the middle of the room. Yep, that's the test.
What if the air conditioning's on?
Well, the pizza box
There's
is
a fan.
open. All right, this is good. You're really messing with my metaphor again.
I'm just thinking like a lawyer.
Okay, maybe pizza is not the best medium for this doctrine. An hour.
One ice cube out of the freezer. You put it on the
ice
table.
cube, Mike. Is it a big whiskey cube? Is it round?
It is a 1 inch by 1 inch by 1 inch ice cube.
Okay.
In a 70-degree room.
We're gonna find an SI measurement for the legal ice cube
on a wood table that is at room temperature.
I love this actually. Yeah, 25 degrees
let's
Celsius.
do this. We have the power to do this.
This is great.
We're going to make this judicial law.
Or we can just make it an hour. We actually have units for this sort of thing.
we give every cop a laxative, and they have to. A question has to be answered before a cop leaves.
Or the Serapov-Ipecac test, like in Family Guy.
Just cops constantly puking in every interrogation.
I mean, that would be incentive for the cops to really make sure that they had the right person. They were going to go through all that.
Can we just make it a law that there's just always a lawyer?
Huh.
Even if it's not going to be the permanent lawyer for the case, there's got to be some representation.
If we can
question. You get a lawyer for the initial questioning. You can change lawyers to your preferred lawyer after, but there has to be a lawyer.
If we can post up a traffic cop at every single work site in the state, we can do this. You just need a lawyer in a 15-minute radius of every municipal jail, every holding cell.
Seem to be like, I don't
think that's that hard to do, honestly. Like, that seems actually pretty reasonable.
Be the lawyer on duty at the police station for the day.
Yeah, good way to give a leg up to junior lawyers.
Shifts. Like, every lawyer, you get jury duty. Every lawyer's got public defender week. Okay, you're at the station. If there's things that come in for questioning.
Oh, I thought you were going to imply we just draft lay people to be the lawyers.
They have lawyers. They have that duty lawyers at the courthouse. If somebody comes in or they're just fresh arraigned or something, and it's who's their lawyer? They don't have appointed or the regular lawyer's gone. Then just some random lawyer will be like, I'll be their lawyer for this.
I could easily structure it so that every police interrogation had to have a lawyer present.
Oh, so just
yeah. It's got to be independent. It can't be someone who's because then it would just be it's the police's lawyer.
It's the police lawyer, yeah.
There's got to be some separation there. That's why I think a rotating, it's not the same guy. Actual lawyers in the state, they serve.
You can have celebrity guests
a year or something.
Yeah, no,
and it's just we just all of these problems go away because this whole thing there's a lawyer to answer these questions,
and so it's not even about it's just automatically we want to ask you some questions, and then it's just here's your lawyer for for this interrogation.
It's just automatic. We're going to question you.
We are.
The lawyer has to come in before questions can proceed.
We are the most activist court in history,
and I mean if the person in question has their own lawyer they can call, they have the option of, let me call my lawyer. If they don't,
then they have a lawyer
are
fight.
Hey, Bob lawyer is on duty today. Here's your lawyer for this. You can change lawyers at another point, but you have legal representation.
Oh man, I love it. I love this. I love our sweeping changes.
I'm actually happy with this idea.
Yeah, you cooked. That was good. Mm-hmm. It took us a second, but we got there.
Yeah. So we have a ruling and then some.
I would love to have a criminal defense lawyer on to just comment on just this ruling right here.
Every private law firm in the country is salivating about this. Yeah. Oh my God, think about the billable hours.
Well, no, it's public service. So it's like jury duty.
Yeah, every lawyer is obligated to donate, a proportion of their time. And
every single lawyer just turned off the podcast.
Well, no, because I think
it's
that's
a week out of the year or something. I feel that's a reasonable ask.
I think with a lot of licensed professionals, there is kind of a hey, you should really consider, if you can donate some of your professional time doing something.
It's like lawyer National Guard. I love it. Okay.
Well, it's like lawyer jury duty is what it is.
Yeah. Okay. Yeah.
It's just it's your obligation as a citizen. If you get a law degree, then you're in criminal law, especially.
Yeah, to be bar certified.
Yeah, it's just a thing you have to do.
I believe
I don't hate it.
At least one state does have, I think it was Louisiana. I think it was This American Life. Shout out to This American Life. Had a episode where in Louisiana, I guess they have a rule that says if there's not enough public defenders, then they will like pick somebody at random from the list of people who have passed the bar.
No.
And assign them. And this like personal injury lawyer got a criminal case, and he looked at it and he was just like, I don't want to do this. This isn't what I want to do. And then he looked at the case and he was like, the prosecution has nothing. Let's do this.
Yeah, but I think in this case, it's like the lawyers aren't like, they're not beholden to anything like past the questioning.
Right.
Like the lawyers are just there for the initial contacts of the police and the.
So they're the interrogation lawyer.
Yeah, essentially, right? And they're there until the real, well, not the real, but like the chosen lawyer comes in, or the interrogation runs its course.
Yeah,
and I think a lot of these problems other problems will probably show up, but I think a lot of these like last bunch of cases we did, like that solves a lot of it.
Oh yeah, and then if the person just invokes their right to not talk to the police, then like
the lawyer's there to be like, he's invoking his right.
Yeah, he's invoking his right. We're not doing this. Lawyers out in and out 5 minutes. They've done their thing.
Love it.
Really like this.
Yeah,
really like this.
Yeah,
feel strongly.
And then we think about how much this is going to cost. Don't think about that. Don't think about
that. Has nothing to do with anything.
No, you don't cost. That's why it's a public service. It's like the jury duty. It's a public service. It costs nothing.
But even the administrative overhead of selecting the people and cycling them in and out and all that, like it's just.
I feel like that's a reasonable cost. Like,
fair.
Fine, my taxes can pay for that. I'm fine.
Yeah,
okay. That's the extra 0.002 cents per year that would cost.
That means a few suspects get to keep their fingernails. I'm all about it.
Yeah.
All right. This feels very much like a. Mike has written an opinion.
I have,
yes.
And everybody has signed on to that opinion. Does anybody have any addendums or anything else? Or is it just like, this is a unanimous?
Or separate concurrences? Or
Yes.
I'd like to express my disappointment that we didn't get a song this episode, but that's it.
All right, guys. Well, I guess now our last thing to do is define pornography.
And define it.
It sounds like we have a unanimous concurrence on Mike's opinion, which, if I understand it correctly, on the first part of the question, which is like, do we need to throw out this person's admission of guilt, such as it was? The answer is yes, because they clearly were trying to remain silent, and it doesn't seem like they were really all that cooperative, and 3 hours is a long time to be talking to a wall. Followed up with this notes, or this really kind of points at the fact that like everyone should just get a lawyer when the cops talk to you. Is it at the point of detention? Like, if it's at the point like where they're going to Mirandize you, because like the cops can just talk to you and not Mirandize you if you're not like the person they're investigating, if they're not interrogating you.
If it gets to the point where we're at the point where we need to start reading Miranda rights, then a lawyer needs to automatically be
okay. You have a right to an attorney. If you don't have an attorney, this is Bob.
Yes.
Yeah, even if you have an attorney, Bob's going to sit here until that attorney gets here. You know.
Yes.
He's chained to the radiator. He can't go nowhere.
Cool. All right, we have our opinion.
Wow.
And it is unanimous. I'm going to quickly comment on that opinion. In that, I love it. Every police interrogation will go thusly. Here's your Miranda rights. Where were you on the, you're being informed that you shouldn't answer any of my questions and you're not going to talk to me? Cool, have a nice day.
I mean,
it's going to make the cops do the job, right? Like, do the groundwork, do the investigating.
Oh no, the cops are going to have to do the job.
Yeah.
No more shortcuts.
I'm fine with that outcome. That outcome seems like the way it should be.
Yeah.
Okay.
Yeah. All right.
We're going to force these pilots to actually fly the planes.
Tune in next time when we just straight up abolish the police.
Well, Nikki, tell them what they've won.
Anarchy.
Yeah. This was like a really cool discussion. All right. So the real case was argued March 1, 2010.
Ooh,
that's one of our most recent ones.
Decided June 1, 2010. It was a 5-4 decision. The majority opinion was written by Justice, I think it's supposed to be Kennedy. So basically, the majority found that VT's argument that he'd invoked his right by remaining silent to be unpersuasive. So basically, he didn't say that he wanted to remain silent. He didn't say that he wanted to remain silent. He didn't say that he didn't want to talk to the police, and which would have been a clear invocation of his right. So according to the court, the purpose of Miranda is to make sure that the accused is advised of their rights and understands them. And so, silence along with, the person understanding the rights and then behaving in a way sort of that, it can be taken as a waiver, as an implicit waiver of one's rights. So if the prosecution proves that, the Miranda warning was given and that the accused understood it, then as long as there was no coercion, then whatever statement they make, that's an implied, waiver of their right to remain silent.
Huh.
So they're saying, basically the court had previously held in Butler that like a suspect has to unambiguously invoke their rights, like to a lawyer. So like if they make an ambiguous, equivocal, or no statement about a lawyer, then they haven't invoked their right to a lawyer. The police don't have to end the interrogation. They don't have to seek clarification that the person wants to invoke their rights. This is kind of new because it's talking about silence specifically, but they're like, there's no reason to require a different standard. We can just do the same thing. And, if you make it very clear, if the person actually unequivocally states that they want to remain silent, then that provides the police with objective information on how to proceed, rather than requiring police to, quote, make difficult decisions about an accused unclear intent and face the consequence of suppression if they guess wrong. And so they also say suppression of a voluntary confession in these circumstances would place a significant burden on society's interest in prosecuting criminal activity. And in the decision, they're like, well, maybe the suspect wants to listen to the interrogation questions to get additional information. Maybe, this gives them the opportunity to really think about what they're doing and make a more informed decision about speaking with police. So his answers to the questions about praying to God for forgiveness, basically the guy waived his right to remain silent, as did his sporadic answers to the interrogation. If he wanted to remain silent, he could have just remained silent, literally, or unambiguously invoked his rights and ended the interrogation. Therefore, after giving a Miranda warning, police can interrogate a suspect who has neither invoked nor waived his or her Miranda rights, and they are not required to obtain a waiver before moving on to the interrogation. So that was the main opinion. Justice Sotomayor had some shit to say about this.
I can only imagine. I have some shit to say about it.
So she was like, yo, Miranda specifically state that like police have to, tell suspects of their rights and that Miranda was and in its subsequent cases were based on this idea that custodial interrogations are inherently coercive. And she's like, yo, this court has previously held that if an individual indicates in any manner at any time prior to or during questioning that he wishes to remain silent, or if he states that he wants an attorney, the interrogation must cease. And their statements can't be admitted. Basically, the state has a heavy burden, and she's like, y'all are just shifting this burden away from the state, which was not the original intent of Miranda. And she was like, I don't know, it was really striking that he was just not responsive. Like, the police were kind of after him and telling him that this was his opportunity to give his side of the story. And she was like, despite this, the court decided that he had waived his right because he didn't want a peppermint and because his chair was hard.
That's insane.
So
you have to say, I ain't squealing, coppers, or else.
So she was like, I don't know. I question whether this guy actually waived his rights. And she's like, this is a direct quote. I cannot agree with the court's much broader ruling that a suspect must clearly invoke his right to silence by speaking. She's like, this is bananas. Like, the guy was being silent, so let him be silent. And she's like, by this logic, if you're saying that somebody has a right to remain silent, that you're not, that doesn't necessarily convey that they have to speak to protect their right to silence. And like, why would the police like explain this distinction? So, and then she's like, there's ample evidence that suspects often use equivocal or colloquial language in attempting to invoke their right. So she's like, this basically gives police the green light to just interrogate somebody at length, even if they refuse to answer questions, in the hope that they get like a single incriminating response that can prove that they waived their rights. So
maybe you just want to practice a Shakespearean monologue and like, oh, captive audience.
Finally, my one-man play can go on.
So yeah, that's what the court had to say. And there's actually a lot of research on police interrogations. And actually a lot of it's done by psychologists. So there was, and of course, legal scholars as well. So basically, well, I'm just going to kind of summarize, some of the research stuff that's come up, because there have been ongoing questions about whether just telling people their Miranda rights is actually effective, especially given evidence that interrogators have tactics to override resistance and to elicit a confession. There's like training and stuff that police get on how to be interrogators. And Saul Kassin and colleagues recently, like within the past, 3-4 months, published a scientific review paper. This was a second paper. There was a first paper from years ago that was like, here's everything we know. And then they did an update of like, here's all, stuff that we've learned since. So basically, and it was basically most anybody who's ever done research on interrogations who kind of joined forces to write this. So interrogation is described as a guilt presumptive process. So it's this interaction that's led by an authority figure who has formed a strong belief about the suspect and who measures their success in terms of like whether they're able to extract a confession. And so interrogations are designed to increase the anxiety associated with denying an accusation and to decrease the anxiety associated with confessing. So research indicates that about 80% or more of individuals waive their Miranda rights to silence in counsel when they're questioned by police. So this makes your idea of like an automatic lawyer at the station like super interesting, just in light of that. And where this comes to be really problematic is with individuals who are innocent.
No.
You don't say.
That's crazy.
So people who are innocent tend to not really appreciate the significance of their rights. And so psychological literature discusses, it's called a phenomenology of innocence. So there's this belief that because they didn't do anything wrong, they have nothing to hide, everything's going to be straightened out eventually. This is also really naive, and this leads people into a trap that could result in the phenomenon of false confessions. So
they also don't do well under torture at all.
Yes, although you could say that the Supreme Court outlawed that in Brown versus Mississippi in 1936. We're going to gloss right over the Chicago Brown sites that they were finding that existed up until the 80s, 90s. Anyway, we're going to moving right along.
We're literally sending people to Guantanamo Bay as we speak right now.
Oh, Guantanamo Bay exists in a hammer space that's outside of the Constitution.
Cuba. Hammer space.
That's
also known as Cuba.
Yeah, also known as Cuba. I mean,
where
as
Bugs
far
Bunny's
as
from.
Yeah. But yeah, I mean, basically, like, yeah, so research indicates that most adults just don't fully understand and appreciate their rights. People can be prone to inaccurate beliefs about their rights. So like, once you give up your right to silent, like if you do it once, then it's like permanent, or that you can ask for something to be off the record and it can't be used against you. That's not a thing. That's not a thing with police. And
officer, off the record.
Yeah, off the record though.
I did.
Yeah.
But
oh yeah, no, I killed that guy. Yeah.
Don't write that down. That was off the record.
and making equivocal statements, so saying like, I don't know, I might need a lawyer. Do I need a lawyer? That is not invoking your right to a lawyer. People tend to think that just mentioning one is invoking, and it is absolutely not. And a lot of people tend to believe that if you invoke your rights, then the police and the courts will just interpret that to mean that you're guilty. And that's actually a judgment that lay people make. So there's studies of lay people. There's one done by Lawrence and colleagues where lay people associate silence with guilt. But in the legal setting, like it's specifically written and documented that like you can exercise your rights in a criminal proceeding and that can't be held against you. But lay people don't know that, but then also research evidence shows that people who are guilty and people who've been previously involved in the legal system tend to invoke their rights more often than innocent people do. So, and there's been, studies of both lay people and students earning degrees in like law enforcement fields to kind of show that people tend to associate invocation of rights with guilt. Also, according to research from the Innocence Project, since 1992, when the Innocence Project was founded, false confessions contributed to nearly 30% of DNA exonerations in the U.S.
Wow. I would expect that to be in the teens at most. That's incredibly disappointing, but also somewhat not surprising.
Yeah,
I mean... You know what? Might solve a bunch of these problems?
Mm-hmm.
Just having a lawyer there automatically.
Did we name our doctrine? Were you unanimous on the name?
Oh, I don't think you guys did.
We haven't thought of a name.
I don't think we named it yet. We have to workshop.
Anyway, should I run for Congress?
Yeah.
Do I have the chops? I don't know. I think this is a good idea.
Do you have the money?
No.
Yeah, you need the money.
Run for Congress. You can take my idea.
I mean,
all right. Well,
I guess
I have
coming up, so.
a ton of money. Yeah.
Yeah, you got to run for Congress.
Fine.
So, and Jarrett made mention of vulnerable populations, and there is something to that. There's, people with limited education, people of minoritized status, people lacking experience, communities lacking experience with the American legal system, cultures that place high value on compliance with authorities. Yeah, they might be more at risk here. And psychological literature identifies vulnerabilities associated with impaired understanding of rights and the implications of rights, and coping abilities to cope with interrogation. And that includes limited language proficiency, a lack of intellectual capacity, so like due to some sort of developmental disorder, or mental health problems, substance use. Also, life adversity and post-traumatic stress has been identified as a vulnerability. And youth, like young people, like 15, 16, 17-year-olds, don't really get it as much as,
I think that goes into early 20-hood.
Yeah, I mean, this does kind of dovetail with the literature about, the maturation of executive functions and brain development.
I had a buddy when I was younger who truly and genuinely believed that constables couldn't pull you over. He was 17 at the time, so I don't know. I'm just that's my contribution there.
Really, the disability with young people is just that they're dumb.
Yeah. I mean, that's basically like they're young, they're dumb, they don't have the life experience, they just believe things.
But then again, there are plenty of middle-aged sovereign citizens, so
I say also Facebook. Yeah, Facebook has really upped that to middle-age and seniors.
I mean, okay, but a 15-year-old has an excuse.
Yeah, that's true.
Like,
I was traveling.
Yeah. Like a 15-year-old, it's like, we get it. We understand. You'll grow out of this in a few years. A 46-year-old
ChatGPT what the law is, and
God, we're in the worst timeline.
But that's why this podcast is so important, you guys.
To show that we should have automatic lawyers at police stations?
Yeah, seriously, if you're a lawmaker and you happen to stumble upon this episode, run with that.
Do that thing that we said.
Make it happen.
Yeah.
So what on this one? Because I always like to. So what? Why did we bring you this case? Well, number one, Would make you suffer a little bit by making you do a very similar case twice in a row, and make your brains hurt a little bit. And so, I feel
3 times
like
in a row
mission
at this point,
accomplished.
right?
What's that?
3 times in a
Yeah,
row at
because
this
we
point,
had
right?
we had we
You
had
got a theme.
Connolly.
Connolly. Yeah, okay.
Yeah.
So there's that. Nikki had mentioned to me research around, how young people don't really understand the Miranda rights, their Fifth Amendment rights or whatnot. And so part of it being an educational podcast was selecting cases that we thought, the turnage was fun. That's episode 10, season 1.
The horse poop.
That's the horse poop episode. We have fun. We have fun here. But I don't think that, that episode is maybe the most educational. Apart from,
Speak for yourself.
as Mike put it in that episode, if I'm close enough to the back of a horse that it can poop on me, I'm too close to that horse.
Yeah.
That's educational. But
Yeah.
I digress. A case like this, I think, is really important from an educational perspective because you might think it seems pretty intuitive when they say you have the right to remain silent, and so you shut up. But they keep asking you questions. How long are they going to keep asking me questions? How long do I have to sit here? It's like, no. There are specific magic words that you kind of need to know, and you need to know when to use them. It's a little, it's not dissimilar from what sovereign citizens think. It's just
It's
sovereign
like ordering
citizens.
from the Five Guys menu. You have to know
Right?
the
Yeah. What's the secret
words.
menu of civil rights? So, but I think the big thing from a historian's perspective, putting my history hat on, is the court that decided Miranda and the courts that have come since Miranda are very different courts. And what we have seen since Miranda was, I think it was a very liberal court that had expanded your civil liberties. And since then, it has been more conservative courts constraining that idea and trying to sort of work within the Miranda framework while at the same time strangling it a little bit more each time. And so to me, I personally, I like the idea of like, look, if the cops are gonna come, if the state's gonna come at you, you get an appointed lawyer, period, end of discussion. The other thing that I was thinking coming into this episode was just sort of like this idea that any part of this is ever implied, or like when we're talking about trying to get to like absolute truth, right? That is the point of having a trial, is, or at least coming to an agreement on a version of the events that happened, right? That's kind of what a trial does. It allows two different sides to explain what the events were and how they transpired, and then 12 people, if it's a jury trial, get to decide which one of those seemed to be the most compellingly accurate version of events, right? So it's why you can say stuff in the real world that when put under oath in a courtroom you would never say, right? Because you don't have to be truthful out in the real world, but you do have to be truthful, at least as far as we can prove that you are or aren't in court. And I kind of thought, as I was reading through this case and the results, that there's so much squishiness, and the courts seem to be okay with a certain level of squishiness. And I really just thought you took it one step further than I was thinking. I was just thinking like, the cops don't get to ask you a question until you tell them definitively, yes, I will answer your questions, right?
You like the extra check mark on the PDF document.
Not, yeah, I said, but like, in a way that's, why do we leave it up to the, I mean, I said this in my argument, why do we leave it up to the citizen when the state has these incredibly well-trained, high-budgeted people who we could place the burden on instead?
Well, like that extensive discussion that these justices were doing about, well, what's silence and is it communication and like the pizza rule? I feel, and this is just as an uninformed layperson, that the court was kind of like, we don't want to do all that. Like, y'all figure it out. Like, we're not trying to get into this whole conversation about, the cold pizza rule.
Yeah. I do think also, too, we have to remember that whether something gets into evidence there is a process for that. And so what we're doing here is informing the people who actually make those decisions, by which I mean, when you go to trial, your trial judge determines what does or does not end up in evidence, not the Supreme Court, except so far as the Supreme Court says, here are the rules we would like you to abide by. If the trial judge decides otherwise, it'll probably get challenged if it's egregious enough. And so the Supreme Court ruling absolutely matters, but it's that person in that moment who actually makes the decision. It's not like the Supreme Court is reviewing all of the evidence everywhere. So they're trying to lay out a framework that allows other decision makers to sort of like hold something up like a flowchart and say like, okay, in the spirit of, Berghuis v. Thompkins, the person didn't explicitly say they were asserting their right to silence. So, but then you could always, the other thing too that bothers me a little bit about this is even in Miranda, it says you have a right to remain silent. You can opt in and out of that right at any time. So you could talk to the police for 20 minutes and then you can be silent. Or you could not talk to the police for 20 minutes and then you can talk to them, right? It doesn't say once you've invoked, that's it forever. Like, it's up to you. But the fact that they leave it, that any of it is implied and it's not like explicit, that part boggles my mind. Because why would we introduce doubt or interpretation? Like, oh, he scratched his nose when I asked that question. I think that was kind of responding. So we're going to ask another 3 hours of questions.
Wink, wink, nudge, nudge.
Right? Yeah. Like, come on. So
yeah, or like rocking back and forth is nodding. Yeah.
Yeah. So who's to decide? And I guess ultimately it's the trial judge. But still, though,
just put a lawyer there from the beginning.
Just put a lawyer there from the beginning.
That should be the name of the doctrine.
Yeah, just
lawyers everywhere.
Put a lawyer from the beginning doctrine.
Yeah.
Put a lawyer on it.
All right, so now that this podcast is going to change law in America, you think someone's going to listen to this and be like, wait, how come we never thought of that?
Good news, everyone. Your taxes are going up.
No.
Your taxes are going up in order to protect your civil liberties.
Although I feel like what would also happen or probably happen is just like, I mean, it would just be under the same budget as like public defense services, and just public defenders would just have.
That's why I think it's an on-call thing. You don't.
Yeah.
It's like most people have. I have jury duty this week. I haven't been called in because there's been no jury cases. But like, if you're a lawyer, you've taken the bar exam. Okay, there's one week out of the year where you're on call.
Oh, so it's like the National Guard of lawyering?
Yeah, well, this way, because you don't want it to be a state prosecutor, right? In any way. You don't want it to be someone who's always at the police station because you want that separation. Mm-hmm. So I think you cycle through, okay, if you're in this state and you are a lawyer in this state, 1 week out of the year, we might not call you in, but you're on call. If we have to question somebody,
mm-hmm.
You got to be there. Or you got to find someone who's going to be there. So
the only thing that I think is missing is some sort of extra piece of administration. Like when it's all over, you have to get like emailed like a survey. Would you recommend your lawyer?
Yeah. Yeah. And it doesn't be that person's not the lawyer for the whole case. That person is just there for the interrogation, and then like they're on call. They don't have to stay at the police station. They're just on call. Like, oh, okay, I got to go in, and then
I mean, it could be remote at this point. They could zoom in on it for sure with like cat filters and everything. It's the quality control that I think is worth considering. But this was a wild one.
Yeah. I was actually expecting you guys to go with Jarrett. Like I thought this would be the line, and you kind of did, but you gave my thing a lot more thought than what I thought you would.
You went first.
Yeah.
Yeah. Yep. Definite first mover disadvantage in this game.
Yeah.
Hey, I'll take what I can get.
Right? You scrapped one out, man. You did it.
Oof. I on the website, I don't know if we're going to do this, but I would like to do this. I mean, I don't want to necessarily do like win-loss records. I want to do number of justices who have agreed with you. Right? Because it's like, well, you could lose, but you could still convince one person to come to your side, right? Like,
yeah, you can get points.
You should get a point for that.
Yep.
Well, we didn't agree with the court on this one, but I feel better about our ruling.
Yeah, our ruling was dope.
Ruling.
I do think that like criminal defense attorneys would basically like 100% agree, because like pretty much any lawyer that I've talked to has, where something like this has come up, it's just been an unequivocal, don't talk to the cops. Just don't talk to the cops. And if there was constantly, a defense lawyer available at a police station,
So don't answer that. Don't answer that. Or
they would take them into a room and then step out of the room and then be like, my client's not talking to you. Like the police would never talk to anybody. The lawyer just be like, no, my client's not talking to you. You can put him in custody or release him or whatever, but you're not talking to them.
But I mean,
Done.
people do talk to the police in the presence of their lawyers. Like,
if
there's
and a lot of times there's like a lot of discussion with the lawyer, a lot of whispering, and it's not uncommon for people to only accept questions through their lawyer, and a lot of times in writing. Oh, you have questions for me? Send them to my lawyer in writing, and then I will send you a response through my lawyer in writing.
Yep. And so those are the people that have the advantage of actually having a lawyer from the start. The people that don't have a lawyer from the start are the people that get screwed. Our solution would give everybody that same level of justice.
this is the Oprah lawyer doctrine.
You get a lawyer.
You get a lawyer.
You get a lawyer. Just to finish things out, for anyone who hasn't seen it, anyone here or anybody who's listening to the podcast who hasn't seen it, there is a professor at Regent University named James Duane, who at the moment it was 13 years ago, but there's a YouTube video you can find. It's called Don't Talk to the Police. It's a 46-minute lecture. He does the first half, and then he invites a police officer up to do the second half. It is excellent. It's funny. It's absolutely worth watching. Cannot recommend it enough. It is Don't Talk to the Police, the Regent University School of Law YouTube channel. James Duane, Professor James Duane. Go watch it. He also has a book, which I believe is called
You Have the Right to Remain Innocent.
Yes, which is also very good. And you can go read that if these topics interest you. So, but I think that will do it for us here at Relitigated for this episode. Thank you so much to our justices. Thank you, as always, to my co-host, Nikki. Thanks for being here. Thanks for listening. And we will catch you in the next one. Goodbye.
Bye.
Thank you, friends.
So, yeah.
Well, there you have it. A unanimous decision from our justices in favor of Thompkins, with a decree that everyone should automatically get a lawyer for any police interrogation. That's it for this episode, but before we go, thanks again to my co-host and to our justices. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Research was done by Nikki. Audio mixing and producing was done by me. Thanks for listening. Please subscribe, rate, and comment so other people can find us. For complete episode information, including references, please check out our website at relitigated.com. You can also catch us on YouTube, Instagram, Facebook, Threads, and Blue Sky. Please help us spread the word. All right, until next time, I'm Jarrett, and this has been Relitigated. Take care.